The attorneys in 127299, State of Kansas versus Kyle Romey, to please come forward. Feel free whenever you're ready.
Good morning, and may it please the court, Grace Tran on behalf of Kyle Romey. In this case, there was insufficient evidence of premeditation, and also Kyle was denied his right to a fair trial because the district court refused to admit defense evidence, refused to give a requested defense instruction, and did not properly instruct the jury on premeditation. Kyle's conviction should be reversed. First is insufficient evidence of premeditation. In this case, the state did not put on evidence to show that Kyle had thought about beforehand and formed the intent to kill in this case. Ultimately, this case is a black box. No one really knows what happened inside that house on the day of the incident, and none of the state's evidence shows that there was any intent to kill formed before the act. And all of Kyle's behavior before and after the case did not support that there was premeditation here. Kyle, by all testimony, was helpful to his mother and had a good relationship with her, and also afterwards showed distress and got his sister to go and see their mother and lay down beside her and was attempting to comfort her. And so none of this evidence shows that there was intent or that he had formed premeditation beforehand.
Why isn't the evidence that there was an extended altercation, that evidence that he switched hands and evidence that he switched weapons are enough for a jury to infer? I'll give you that it's thin, but why isn't that enough under the law?
That's not enough because it relies on impermissible inference stacking. So with the example of the fact that she had a lot of injuries, right? So the ME testified the extent of her injuries. That leads to an inference that this took a very long time, which leads to an inference that there was enough time to form premeditation before the act or during the act of that. And ultimately, this court doesn't allow inference stacking to prove elements of crimes or to say that they're sufficient for a jury to have found them. And so because of all of this,
Can I follow up on Justice Biles' question? I think just honing in more specifically, there's evidence that his hand was swollen, a physical altercation, and then there's evidence that a instrument was used. So it seems to me that the change in tactic is contemplative. And I don't know that that is stacking inferences.
Your Honor, I think that even the evidence that his hand was swollen, that an altercation occurred, that even goes to the point that the defense had requested a voluntary manslaughter instruction, and with the language of a sudden quarrel or heat of passion, based on evidence of an altercation, evidence, of wounds that occurred that may have been defensive wounds, and that wasn't given. And so,
Yeah, it may lend credibility to that requested instruction, but are you suggesting then that that would be a reasonable inference, though, that switching of tactics in terms of the assault demonstrates contemplation?
Your Honor, no, I don't agree that that necessarily demonstrates contemplation. I think that ultimately a lot of things can happen in the midst of a highly passionate fight or altercation that occurred. And just because one's hand might get tired during such an event, that doesn't necessarily mean that one has thought about it and formed the intent to kill before that has occurred. So no, we don't necessarily think that that shows intent. So moving to the voluntary manslaughter, like I mentioned, there was evidence here that pointed to an altercation occurring, pointed to a sudden quarrel or a very highly passionate, violent event. And that's the standard for giving a requested lesser, is that there must be some evidence to uphold to support the conviction. And so it was error in this case for the district court to not give the lesser that was requested because there was this some evidence. The house was in disarray, the furniture and items were broken. Like we've mentioned, Kyle had injuries to his body, and obviously as did Denise. All of this evidence supports that there could have been a fight that occurred, and would support that there was a sudden quarrel, a heat of passion. And this goes to several of the errors that occurred in this trial, which all get to that the jury was not allowed to fully evaluate Kyle's mindset and Kyle's state of mind at the time that this occurred, because the district court did not give this lesser that would have allowed them to consider this alternative circumstance. Also, that the district court did not let the defense evidence in of intoxication, which would have gone to Kyle's mindset. So ultimately, that's the overarching problem in this case, is that the jury didn't get to fully consider all of these circumstances when this case was such a black box of what happened. And so the jury didn't get the opportunity to consider all of the evidence, all of the potential charges or lessers. And so.
But they did get some lesser included offense instructions, I believe, right? Second degree. So if the jury didn't believe that this was a premeditated act, there was an alternative for them to convict on. When we are trying to ascertain whether any instructional error is prejudicial, we have to be, since you requested the instruction, it's not clear error, it's a lesser standard, but that the outcome would have changed. How do you respond then to that the jury didn't adopt any of those lesser included instructions that would have maybe evidenced that a theory other than premeditation?
We would suggest that since voluntary manslaughter includes these additional elements of sudden quarrel, heat of passion, that would have been a more appropriate charge or lesser for the jury to consider. And given the evidence in this case, that would be, much more likely for the jury to have gone for. And therefore, that's why the state can't show beyond a reasonable doubt that this was a harmless error. And so.
How do we weigh, in looking at the harm, whether the error was harmless or not, the fact that the defense filled in a narrative, a theme of what happened, and in the closing arguments went so far as to say that those injuries to your client were likely caused by whomever harmed mom, and went so far as to say it wasn't his mom that caused the injuries? Does that really leave the jury much room to have come up with the theory you're now asking us to adopt?
Your Honor, ultimately, of course, defense can shape a narrative and put forth versions of events. And I think defense did that in multiple different ways throughout this trial. Like the comments you've mentioned, also putting forth that potentially he was intoxicated to the point of not being able to form intent. And so ultimately, the defense's comments are just argument, and they may suggest to the jury ways that they should view the evidence, but ultimately the jury is the one, and they're instructed so that comments of attorneys are just that, comments, and that they should view the evidence. And so I think that if they were given the law from the judge that that also could have formed the way that they viewed the evidence, in that they would have been able to use that law and look back and see if the elements of voluntary manslaughter had been met. And so also, like I mentioned, there was this exclusion of defense evidence, which again goes toward this overarching theme of the jury not being able to fully evaluate Kyle's mindset. And
well, the defense evidence that you were requesting was a video of his interaction with law enforcement post during the time in which he was being interviewed? And wasn't there evidence that he had ingested methamphetamine either through the consumption of the water plus maybe other consumption of drugs after the attack?
Your Honor,
So what's it relevant for?
Your Honor, there was evidence that of possible drug use that Kyle had after the event. His sister.
Strong evidence, it seems like, from various witnesses.
Well, so the evidence from his sister was that he had drank bong water after the event. There wasn't even testimony of what that bong had been used to smoke or to ingest. So the evidence, which was the video, also a lab report that showed that he had methamphetamine and amphetamines in his system. There wasn't testimony that the bong had been even used to smoke methamphetamine or amphetamines in a way that there would be that residue in its byproduct. But ultimately, there was also evidence that he had used before the event. And so that's why this evidence was relevant to show his state of mind at the time, because his sister had testified the morning of the death that before this ingestion that he had been acting erratically, as if he had been under the influence of methamphetamine, that he had been acting effed up. He told her that he had blacked out that morning. He did not remember what had occurred. And so ultimately, if the standard is for relevancy, any tendency to prove a material fact, because there was evidence that he had used drugs before, this evidence had some tendency to show. And of course, any issue of timing could have gone to the weight of the evidence for the jury, but ultimately the jury should have been able to review that evidence and make those determinations as the fact finder, instead of that evidence not being allowed to go to them at all. And so, and again, this evidence goes toward this critical issue in this case, which was that no one knew what was going through Kyle's mind at the time. And so, because again, the jury wasn't able to consider, does this evidence go toward an inability to form intent, to form premeditation before Kyle's right to a fair trial was violated in this case. And I see that I'm running low on time. I would stand for any further questions. And if not, we would just ask that Kyle's conviction be reversed, and I would submit the other issues on the briefs.
Can I ask you one question about your sentencing issue, your challenge? You're challenging his criminal history A status, and you're doing that through a couple different levels. The first level is the criminal threat convictions, correct? Based on our recent precedent, that seems consistent with that case law. But then he's still a criminal history A because of the personal misdemeanor convictions. So you're challenging the Louisiana conviction to knock out the third person misdemeanor offense. But it looks to me like the PSI shows yet another person misdemeanor, the 2006 Kansas assault conviction, which tells me that you could still aggregate 3 misdemeanor convictions and he would end up as the same criminal history.
Your Honor, I may be incorrect, but my understanding about the assault convictions is that they can only aggregate if they have occurred within a certain amount of time of the crime of conviction, maybe 5 years, possibly.
Well, the PSI aggregated a 1998 and a 2006 conviction, and I'm talking about another 2006 conviction. And I don't think you challenged the 98 or the 2006 person misdemeanor.
That's correct. My understanding, at least, is that with assault specifically, because the level of misdemeanor they can't aggregate unless they are recent enough to the crime. But again, I might be mistaken about that. Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Beginning with issue 1, obviously this court is aware of the standard of review for sufficiency of the evidence claims, but I think it always bears repeating that the evidence is viewed in the light most favorable to the state. And the question ultimately is, Do you believe that not one, not two, not three, but all 12 jurors in this case behaved irrationally in finding him guilty? Because that's what the defendant has to show, is that a rational fact finder could not have sat through this trial, viewed the evidence and testimony, and concluded that he was guilty of premeditated murder. Counsel has pointed to in her argument to the fact that nobody knows specifically what happened in that house. And I would only agree to a limited extent. Obviously, the defendant did not testify. He did not give a statement. We don't have any video of what happened. So to some extent, yes, it's a little bit unclear why this happened. Of course, we don't have to prove the why to prove premeditated murder. But we do have a very good idea. We have physical evidence in this case. We have the fact that this was a beating, a brutal beating throughout her entire body from head to toe. We had broken bones in her head. We had multiple broken ribs. We had a broken bone in her elbow. We had blunt force trauma to her legs. The coroner specifically testified that due to the number and locations of these wounds, that this was not something where it was simply one injury. This is not a case where we could say, well, maybe he threw one punch and it caused damage to her face and she fell and hit her head on the ground and that's what killed her. This is a lengthy beating throughout her body. And so to the extent that counsel is arguing that this is inference tracking, it is not. The coroner testified that these were multiple injuries. And as some of your honors have pointed out this morning, we have injuries inflicted both with his hands and with a weapon, which does, I would argue, as this court questioned counsel, I think that does show additional time to contemplate what he was doing here. I cited in the brief the 5 factors that generally are considered in premeditation. Again, we have a significant amount of blunt force trauma throughout the body. We have an indication that he used both his fists and a weapon. There's absolutely no evidence that the victim provoked him. We have his conduct after the killing, where it appears that he ran the washer to try and clean some of the laundry. He hid the knife in a different room. He prevented his sister from calling 911 and or driving from the police station to the police station. He didn't give any statements or testify, and there are no witnesses, so we don't know if he made any statements before or during the killing. But again, the 5th factor, whether there were injuries inflicted after she was rendered helpless, this was a prolonged beating. And I think that it is a reasonable interpretation of the evidence, the one that the jury could certainly have, that he did continue to beat her after she was rendered helpless here. So looking at all of these factors, our position is that the evidence overwhelmingly supports premeditation. The question is not whether counsel can identify other ways that the jury could have interpreted the evidence. The arguments that she's making are fine arguments to make to a jury. And if the jury had agreed with those, they would not have convicted him of premeditated murder. And I think it is significant not only for this issue, but for some of the other claims raised in this brief and today at argument. This jury was instructed on the lessers of intentional second, reckless second, and involuntary manslaughter, and they were given a voluntary intoxication instruction. And so while counsel has argued that the jury was not really given a full opportunity to consider the circumstances of the defendant's mindset, I think that the instructions and the way that this case was presented to the jury shows otherwise. They heard the evidence, they saw the autopsy photos, they listened to the coroner, they determined that this was premeditated, and I think the evidence overwhelmingly supports that. Turning to issue 2, the exclusion of the evidence that the defense sought to put on. First, I would point out that this was not the denial of a right to prevent a defense, certainly not a constitutional violation. They did get that instruction on, on voluntary intoxication. And there was extensive evidence put before the jury regarding the defendant's history of drug use, or alcohol abuse. There was testimony about some of the items found in the house, including, I believe, a vodka bottle. The jury heard all sorts of testimony and evidence about this matter. The only thing that they didn't get was this evidence about the video that they wanted to show. And I would note, they wanted to show a very short segment of what was essentially a 3-hour period that he was in this interrogation room. And then they wanted to present this lab report. And the court's rationale, I think, was correct. We had the victim's sister testify, or the defendant's sister testifying that she personally saw him smoke this bong water after the killing. We also had her say that when he first arrived at her house, he did not appear to be intoxicated to any degree. And this was somebody who knew him, obviously, who was aware of his history of drug and alcohol abuse. And so I think she was certainly qualified to speak to whether he appeared intoxicated when he got there. And then this video was several hours after the fact. We know he had used drugs in the interim, and the lab report was taken 12 plus hours after the murder. So again, we know that that is going to show that there was some level of drugs in his system because his sister saw him use them after the fact. So I don't think that it would have any value whatsoever, regardless of what that test showing that he has drugs in his system, it's going to show that regardless of whether he did anything before or after the fact. And again, he chose not to testify or not to give a statement, which is certainly his right. But because he did not do those things, and because there's no other evidence that he had used or was under the influence at the time of the murder, the court properly found that those two pieces of evidence were not, in fact, probative. The fourth issue raised, I guess, was the voluntary manslaughter instruction based on the heat of passion or sudden quarrel. And I would just remind the court that it's an objective test governing the question of whether there was legally sufficient provocation. And that has to be sufficient provocation to cause an ordinary person to lose control of their actions. And the case law from this court says that you do not speculate on hypotheticals. You have to have actual evidence to support it.
Does that objective test fall under the factual appropriateness prong of our standard of review or somewhere else?
I would argue that yes, because you're having to look at whether there would be actual evidence, that would be largely a factual determination, having to look at the facts of the case to determine whether they would be, whether it would be sufficient.
Because we know it's legally appropriate.
Yes, it is legally appropriate because it is alleged.
But it's sort of a strange beast when we use the word objective standard. That makes us think sometimes it's a legal question.
Right.
It really is a factual question, isn't it?
That's what I would agree with.
But your argument would be that this instruction was not factually appropriate because the evidence did not rise to the threshold of an objectively reasonable provocation.
Exactly.
Okay.
And I think essentially what the defense has pointed to is the fact that their house was in disarray and that there was broken furniture. But again, you would very much have to speculate on hypotheticals. You would have to assume first that furniture was broken and that the house was in disarray because there was an argument between these two people. You would have to assume that argument and that confrontation had happened at this point during or immediately before the killing. And then you would also have to assume that the victim was the one who provoked this incident and that provocation rises to the level that it would cause an ordinary person in the defendant's position to lose control of his actions to the point where he would then brutally beat his mother to death. So there is very much a lot of speculating that would go into such an analysis.
Well, let me ask you something that strikes me as potentially different here than in Garcia and some of our other cases about, where the evidence was that scattered, an evidence of a protracted altercation. And here it's the forensic examination of the defendant after arrest, showing injuries to, if I get it correctly, the back of his head, swelling on the back of his neck, and abrasions across his back, especially in the lower middle back. Bearing in mind the inferences that you're asking us to draw on premeditation, why can't we infer, or why couldn't a jury infer from that evidence that he was attacked from behind?
I think that when you look at the evidence as a whole, you still can't escape the fact that the overwhelming evidence showed that he was the one who committed a very prolonged beating in this situation. And again, I think that because he chose not to give a statement, which is his right, but because he chose not to give a statement, we would have to speculate as far as how he actually got those injuries.
It's the timing, right? We don't know which happens first.
Exactly. We don't know which happened first. We don't even know for certain whether those injuries to his body occurred at the time of these incidents, at the time of this incident. So I still think that there's just too much speculating that would have to go on in a situation like that. And I would submit that in a normal situation where there is a beating like this, I think it's fair to assume that the victim will try to defend herself or fend off her attacker. And so it's certainly equally possible that even if some of those injuries to the defendant occurred during this incident, that it was as she was defending herself rather than because she started an incident that then provoked him.
Can I ask you one more thing while we're on this instruction? On the if a court were to find that it was error not to give this instruction, and we were examining prejudice, and it really goes to Chief Justice's question earlier, where in closing, the defense formulates this theory about the evidence that these injuries were all caused to both the defendant and the victim by some other third party. But what do we do with that when we know that, well, they didn't get the instruction they requested, which may have opened this vehicle for a different interpretation of the evidence? Or are we just stuck with the record that we have?
Yeah, I certainly think it's relevant that they pursued that theory as part of their closing in this case. And so I think when you look, you can only look at the record that does exist and see what strategy they took here. And so I think that, yeah, it certainly does, in my mind, seem to be very detrimental to their argument of harm with respect to whether the error was harmless, when they themselves are putting this different theory before the jury. And so I think that makes it difficult to then say that that they can firmly convince this court that the jury would have returned a different verdict. I think that in all likelihood that this is a case where they were just trying to throw different things out there, because this is, again, I would acknowledge that we don't know why specifically this happened. This does seem to be a very bizarre situation where, according to the defendant's sister, that there didn't seem to be any history of discord between these two people. And so there is a natural tendency to speculate and wonder why. But I think when you look at, again, the physical evidence, and then you look at the defendant's behavior after the fact, counsel points to the fact that it appears that he was regretful in his actions after the fact. And while that may be true, it simply has no bearing on whether this was a premeditated act on his part. And we might likely never know why he did what he did. But I think when you look at the severity of the beating, the extent of the injuries, the fact that it was all over her body, that it did take time because there were so many different injuries, and that he used both his hands and a weapon, I think that the jury's verdict was certainly very reasonable in this case. And I don't think that the lack of the lone instruction, essentially, that he was denied in any way affected the outcome of the trial in this case. If there are further questions, I'd be happy to entertain them, but otherwise, the state's position is that all of the defendant's claims are without merit and that his conviction should be affirmed.
And the sentencing issue, and I think, you know, our State v. Smith holding that's come in on those criminal threat issues. And so now really we're focusing on the aggregation. And I'm wondering if you understood my questions to your opposing counsel about this third person misdemeanor.
I did, and I, like counsel, I'm not entirely sure of the answer on that. Certainly would encourage the court, obviously, to just look at the PSI in its entirety and determine whether there would be anything else, and if so, then obviously then that would make him an A regardless. And I don't plan to address at length from the podium here the Smith opinion. I know this court's aware that we filed a motion for rehearing in that case that this court denied. We would maintain that the arguments that we made in that were correct, but I know this court has reviewed that, and so I don't intend to argue that here from the lectern today. But we do maintain that that was wrongly decided. But yes, to your point, Your Honor, the court would have to look at the entire criminal history in this case, and even if they could show a problem with the convictions that they have challenged, to the extent that there are still 3 that can be aggregated, then he would still remain in the A box.
Other questions? Thank you.
Thank you, Your Honor.
Fran, you reserve 3 minutes.
Your Honor, unless there are further questions, I would waive my rebuttal time.
I don't see any. So
Thank you.
thank you. Thank you to both counsel. We will take this matter under advisement.